Good morning, everyone. I'm Kathy McGrath. I work here at Liberty Mutual in the legal department, and I am just delighted that we're able to host this training from two organizations that actually have a strong connection to Liberty Mutual. Both of them are grantees of the Liberty Mutual Foundation because one of the goals of the foundation is dealing with homelessness, and of course that's what landlord tenant law is all about. So I'm just really thrilled that they're here. Our presenters are Milton, Wong, and Dick Bauer. Milton is from the Volunteer Lawyers Project, which can refer cases to you directly. Lawyers Clearinghouse is going to talk about its clinics at homeless shelters where clients come and they end up with some interesting questions for those of us pro bono lawyers to work on. This 3-hour training will not make you an expert, but it will make you know enough to be useful and to be a help. And the other wonderful thing about this training is that you're going to get to know Milton and Dick, and when you have a case and you're stuck, they provide absolutely fabulous mentorship. I know it. I've experienced it. So anyway, welcome to Liberty. The restrooms are that way. There's water and coffee outside. Thank you.
Hi, everybody. I'm Mia Friedman from the Lawyers Clearinghouse. I run our legal clinic for the homeless program. So this training is sponsored by Volunteer Lawyers Project and Lawyers Clearinghouse. And so I just wanted to give a quick intro about Lawyers Clearinghouse. I recognize many of you and you participated in our clinics, which is wonderful. But one of the programs we run is our legal clinic for the homeless, where we go into 7 of the area homeless shelters in Boston, and we do legal intake with volunteers from firms and companies like Liberty Mutual, and then our pro bono attorneys with our support and guidance and people like Dick Bauer handle the cases back at their firms. So we have a large percentage of housing cases, but we're not limited to housing. So we also help many folks with sealing their criminal records, with accessing Social Security benefits, dealing with immigration issues, and a range of other civil issues. So that's what we do, and I just wanted to say hi since I'm not one of the trainers today, but I will turn it over to Dick and Milton, and if you have any questions about Lawyers Clearinghouse, feel free to come talk to me at the break. Thanks.
Okay, so thanks Hello?
We need our AV done there.
Okay, so thanks everyone for showing up today. This training is going to be, again, basic landlord tenant law training. It's going to equip you to help out at the clinic and also take on cases full rep. We encourage you to do that. And I just want to reassure you first that your value as a pro bono attorney in all of these things, it's huge because the eviction process can be really complicated and really difficult. People going through them are often unaware of their rights. They're confused about the court process. They're highly stressed out about everything that's going on. They're scared that they're going to lose their homes, right? That they and their family are going to be made homeless and put out on the street. And so you provide a huge amount of reassurance for them and value by guiding them through the process, informing them of their rights, and clarifying this really, really difficult and complicated court procedure. And you're already trained to issue spot and make concise, clear arguments, and these skills are really, really beneficial, even if you just help the clients, fill in a fill-in-the-blank form, even if you don't appear in front of the judge. So don't think that you don't know enough to help or that what you will do at the clinic isn't going to make a difference, because I can assure you that you do know enough and that what you do will make a difference. So thanks for being here.
I'm Dick Bauer, and I'm of counsel with both the Volunteer Lawyers Project and the Lawyers Clearinghouse. How many people are here because you have some connection through the Volunteer Lawyers Project? Great. And how about Lawyers Clearinghouse? Okay. And I'll bet some people I know are both. And that's really wonderful, and both organizations really appreciate it. Well, we wanted to just note here, because people are coming in on slightly different paths, just about a little bit of the differences between the way that the Clearinghouse works and the way Volunteer Lawyers Project works. As Mia said, the Lawyers Clearinghouse Clinic focuses on full representation rather than lawyer for the day, And some of the stuff we're going to be talking about from the Volunteer Lawyers Project focuses on people who are coming in for Lawyer of the Day. So there are slightly different paths coming in. In one case, you're showing up and saying, what can you do with me today? And in one case, you're showing up to represent a client you already know on a case you already know. But most of the substance is going to be exactly the same. Should also note that the Lawyer of the Day clinics are always staffed by VLP, and then along with a combination of Greater Boston Legal Services Center, and the Harvard Legal Aid Bureau. And Lawyer of the Day staff are there to help for both landlords and tenants, but they're also there to help you as pro bono attorneys. So feel free to tap into people, check in when you come in and let people know that you're there, and feel free to ask anytime you could use some help from the Lawyer of the Day tables.
And I just want to say briefly, if you guys have any questions while we're going through this, raise your hand. We'll get a mic out to you. We're happy to answer the questions as they come up. But because we're kind of tight on time, there are going to be some questions that we're just going to have to save for the end, and we can discuss that with you privately. But again, if you have a question about any of the materials as we're going through them, go ahead and get our attention. We'll try to answer the question. So for the Lawyer of the Day clinic, I just want to give a brief overview of what it is to situate you so that you have an idea of what to expect and what's going on when you actually arrive there. So the clinic is actually every Thursday morning at 9 a.m. and we run it until 2 or 3. You as volunteers don't have to stay there the whole time. We're happy that you volunteer anytime at all. But we start at 9, and again, we run sometime until 2 or 3. It's at the Edward Brooke Courthouse up on the 5th floor, and it's outside courtroom 10. That's where we run the clinic. Usually on that day, there are 170 to 190 cases on the docket. Yesterday, there were 213, I think. And we're there to assist pro se litigants that qualify for our services. Okay, so not all of those cases are cases we're going to touch, but we're available, and we try to help out anyone that's there that needs help and qualifies. Okay, when you get there, go ahead and sign in on this guy, the VLP sign-in sheet, so we know who came, and we know we can get in touch with you if there's a question, if we need follow-up on the case. So when you get there, be sure to sign in on this sheet. And there's 4 levels of assistance that the clinic provides, from the most basic to the most involved. It's brief advice and counsel, drafting pleadings and filling out forms, assistance in mediation, which we'll go over. That's going to be our 3rd breakout session, and also representation in the court. We have 2 tables set up at the clinic, and again, it's staffed by VLP in a combination of the legal aid organizations that Dick just mentioned. And between the 2 tables is a cart with all of our materials. So this thing right here where we help out with pleadings and filling out forms. On that cart are a lot of blank motion forms. They'll address most of the typical issues that we run into at the Lawyer of the Day. So we have a lot of things ready to go, and we can sit down with a client, fill those out, and get them filed with the court and to opposing counsel. At the start of the clinic, at the beginning of the day, there will already be a lot of litigants and families, other advocates, social workers milling around the table, and more people will show up around the call of the list, which is at 9:30. So there's some time before 9:30 if people are there to talk to them about their case a little, but it's really, 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 really critical that they get into the courtroom for the call of the list, because if they're defaulted, then it's going to be a whole process to try to get them back on the list. We're going to have to fill out more paperwork. They're going to have to go in front of the judge maybe. So as it gets closer to 9:30, be sure to tell people to get into the courtroom for the call, and we can speak to them after they answer the call of the list. Cases are called in courtroom 10 and down the hall, courtroom 12. Those are the 2 housing court courtrooms. And we have lists for each of them up at the table, so we'll know which cases are being called in which courtroom. 9:30 is actually when the first part of the day starts with the judge coming out into the courtroom and giving an introduction to all the litigants about what housing court is, what to expect, what services are available. They'll speak about our clinic so people will know about us, that mediation is available, and if not, they'll go in front of the judge. Courtroom 12 actually doesn't have that, so if people are being called in courtroom 12, then the call list starts promptly at 9:30. As the parties are called in the courtrooms, they'll have an opportunity to say that they'd like to try mediation, which is a service that the court offers, where the parties try to arrive at a settlement agreement instead of going in front of the judge. But if they'd like to be heard by the judge, they'll remain in the courtroom, okay? And they'll have to fill out an appearance form. And I'll show that to you in a sec. If they do ask for mediation, then the parties will go down to the 3rd floor. We're up on the 5th floor. The mediation rooms are down on the 3rd floor. And as they leave the courtroom to go to mediation, they'll pass by our table, and that's another time where they might want to talk to us, or we might be able to, stop someone who looks confused and ask if they need some help. And be aware, though, that some litigants are actually there, and their court times might be at a different time. It'll say on the docket sheet, on the list that we have, it might be at 11, noon, or 2, or it might say on their notice of hearing what time they're supposed to be at the court. Let's see. Okay. So some of the paperwork that we need you to know about if you're helping out at the clinic is really, really important. Always have a client fill out an acknowledgement form if they want to talk about their case or an issue, right? If they're just asking like what courtroom they're supposed to be in or where the bathroom is, that's fine. But if they want to talk about a case or any sort of legal issue, we have to have them fill out an acknowledgement form first. And that looks like this. So they just have to fill out, it just says, we're here for lawyer of the day, we're not your attorneys yet. Everything you tell us is confidential. We're going to try to help you out with the information that you provide. After they fill out the acknowledgement form, we can start talking to them a little bit about their case, start getting some information, and try to figure out what's going on, okay? Pretty early into this interview process, you're going to be able to figure out generally what they're there at court for, okay? So they'll be there, and they'll need assistance on maybe a motion to remove default, right? Or they want some help having to get their landlord to fix a leak in the roof, something like that. And so once we identify, what they're there in court for, we're going to have them fill out an intake form. Okay, so get a VLP staff member to do that. The intake form looks like this. This is the beginning of the intake form, and we just need to make sure that they're eligible. There are some immigration requirements and some financial eligibility requirements that we need to go over. After they fill this out, the VLP staff member will then continue the rest of the intake on a laptop, and we'll do the intake like that. It'll take several minutes. And then, sorry. Oh no. Give me one sec. And then attached to that yellow intake form is this, which is the limited assistance representation form. It's just a limited retainer, and we'll go ahead and put up there, right here. We'll write in that little bit that says, advice regarding removal of default, and then we can start, and then we can go ahead and give them that advice. If it turns out later on that we're going to do more than that, say we're actually going to draft the motion to remove the default, we can always amend this, okay? But that intake has to be done before we actually, give them advice, draft those motions, go to mediation, or represent them in court. Okay. And after you're done filling out this, or after you're done assisting them, make sure that you then fill this out, and it's an assistance provided form, just so we know what advice we gave them. If there's any paperwork that we help them fill out, attach it to this. We just need to capture the information about the assistance that we provided. I also want to introduce you right now to a couple forms that you might see. Hold on. At the clinic, and I just want you to be familiar with them so they're not a surprise. This is a summary process, summons, and complaint. This is blank right now. This is actually what the tenant gets served by the landlord that brings them into court. Okay, so here will be the date that they're supposed to show up and the reason why they're getting evicted. This is the back side. It's one sheet of paper, front and back. This is a notice of hearing. So a lot of litigants will come up and they'll have this, and this will tell them what they're doing at court, or why they're at court. So here are the parties right here, right? And then this is what's going on. It's a status hearing, and this is the date, the time, and the courtroom that it's going to be in. So a lot of times, they won't know what they're there for, but they're holding on to this, and then you can inform them very, very basically, what's in front of the court that day and what's going on. This is the appearance form. This is the appearance form that I mentioned before. So anyone that appears in front of the judge is going to have to fill this out. This includes litigants if they're pro se, or you if you're doing a full rep case, okay? Just has the parties, who you are, who you're representing, and the case. These two forms right here, this kind of salmon one and this yellowish one, these are for limited assistance representation. So if you don't want to do a case full rep, but you want to appear in front of court, for just one particular purpose for one particular day, advocate on a motion or maybe a quick bench trial, then you can fill out these forms and you will only be on the case for that particular matter. There's a certification process that you have to do, and we can talk about that more a little later on. But I really encourage you guys to get into court and to do so. And if you don't want to be full rep, you're going to be using these forms here. Okay, so when you're doing the client interview, right, we get a client, we identify that there's something we can do. The things that we really need to know are what they're doing there at court that day, and what they want as a result, right, and what kind of evidence they have to support the claims that they want to bring. So it's really important to know what is scheduled at court. Oftentimes clients think they're there for a particular reason, but what's actually going to be heard in front of the judge is something else, right? So when you're talking to a client, you'll ask them, what are you doing here at court? And they'll say, oh, my landlord's trying to evict me because I didn't pay rent. But what's actually scheduled in front of the court, say, is a motion to issue execution because a tenant violated the agreement for judgment. Okay, so that changes entirely what we need to know from the client, because we need to know what the judge is going to be talking about so we can figure out what claims and what defenses there are going to be. It's also really good to know, once that's established, what the client's preferred result is for that day, right? Maybe they want more time to move out, or maybe they're happy moving out and they just want money from the landlord. So it's important to know what the client wants to. And also, we're really going to need to know, whatever claims, defenses that our client has, we need to know what evidence they have to support that, right? Is it going to be receipts? Is it going to be their own testimony? Do they have a neighbor that's a witness that's there that day? Inspection reports? We need to gather all of those things too, all right? Let's see. Other places to get some information are actually in the case file. It's hard to get the case file on the day of because it's going to be in front of the clerk, but if the case goes down to mediation, then we can ask the clerks down there for the case file and figure out what's been filed and all that. You can also find a quick snapshot on masscourts.org, and we can take a look at the electronic docket, and it'll have a list of the things that were filed, but it won't actually have the documents themselves. Okay, so we can kind of get a quick history of what's actually happened. And there is this kind of guide to client questions that's included in the handouts if you want to look over that. It's kind of useful just to kind of set up, how you do an interview.
So we are not expecting you're going to remember all of that. We just wanted you to have some flavor of it so that these things will not seem totally alien when you are at the housing court and have to deal with some of them. But there's, as we said before, there's always staff available to help you with it. The VLP staff will know all of the processes about intakes and all of those kinds of things. So you don't need that in your head. You simply need to know that those are things that you have to be aware of as you're doing it. We've organized the substance of the training today in 3 parts. The next section is going to be about the landlord's case. And then after the break, we're going to talk about the tenant's case. And then after a second break, we're going to talk about mediation. When we started planning this training, Milton had a wonderful idea, one of those things that seems so simple, but somebody has to think about it, and Milton did, which is instead of thinking, what is the information we want to try and get out to you, Milton's question was, what do people who are doing this feel like they need? So Milton recruited Andre, who's over here, to sit down with us and help us figure out what he thinks is most useful for people to know. And the result was a lot of reorganization, a lot of cutting out of stuff that people didn't need to know. So thank you, Andre, for helping us think about this and plan it. A summary process case has we've called it here a typical case, but in part it's because summary process has a very formal kind of timeline. And in the handouts, we've actually given you the timeline. If you take the rules and you sort of reverse engineer them, you will see there's a bunch of steps which have a very specific and formal timeline. And if you know any of the dates along the way, like the trial date, you can work out all of the dates going back and forward from that. So we encourage you, when you're doing these, to look at the timeline, and we're also available to help you think it through. This particular case we're going to give you is a typical case of non-payment for a tenant with a lease. And as Milton said, the starting point of the court case is the summons and complaint. But before the case gets to court, there's typically been a notice to quit. The notice to quit has to unequivocally tell the tenant that the tenancy is being terminated. It has to give an unequivocal date. That doesn't have to be an actual date. It doesn't have to say March 5th. It could say 14 days from receipt of this notice, but it has to be definite and defined by the notice. It has to identify all of the people whose tenancy is being terminated. It needs to tell you what the grounds is. One of the grounds we'll mention later can be no fault for some kinds of tenancies or no substantive reason, but it has to tell you what it's about. And there's no particular formal way it has to be gotten to the tenant, but it does have to get to the tenant. So the legal test is receipt of the notice to quit, not merely the sending of the notice to quit. After the landlord sends a notice to quit, the landlord has to wait for the notice to expire. Expiring notice makes it sound like the notice after a certain date becomes bad, sort of the reverse. The time period expires and then the notice becomes good. But we use the term expiration. Go ahead.
So is a certain type of mailing, like first class mail or like certified mail, is that proof of receipt? Or like is there something that is considered like statutory?
So the question was, is there a particular way to prove it, like certified mail or first class mail? They can send it however they want. If they send it by first class mail, they're going to need some evidence that the tenant actually got it. If they sent it certified mail, they'll have a receipt showing that the tenant got it. Very often landlords also serve them by constables as if they were court process, and then they'll have a return of service from the constable. But if the return of service from the constable just shows last and usual, that's not proof of actual receipt. So if the tenant didn't get it, then there may be something to fight about there. So after the expiration of the notice to quit, then the landlord has the tenant served with a summons and complaint, telling the tenant to go to court. Notice that this is different from most civil practice, where you write the complaint and then you get a summons from the court. Here it's a single form that serves both functions, and the landlord has to use that form. And it needs to be correctly filled out with all of the essential information. So in the upper left-hand corner, you'll see the court. Upper left-hand corner is the court where the landlord filed the case. Sometimes they're in district courts, sometimes they're in the Boston Municipal Court. Most often they're in the Eastern Housing Court for the cases we'll see. And here it's the Eastern Housing Court. The cases in the district and municipal courts can be transferred into the housing court. Cases can't be transferred out of the housing court. The upper right-hand corner is the entry date. And it's a sense sort of slightly misleading because the rules require it to be served on the tenant at least a week before that entry date. So it gets served on the tenant before it is filed in court, and then it gets filed in court after that. On the back, the constable will do a return of service. The tenants will not see that. So the copy the tenants have will either have a blank backside or there'll be a return of service that is not completed. The real one will be the one that gets filed at the court, and you have to look in the court file for that. The summons and complaint has to list the name of all the tenants in the unit and the address of the unit. And then you'll see the date, day, and time of the hearing in the case, which under the rules is officially a trial date, meaning it could go to trial that day unless there's some reason why it wouldn't. It also shows the court address and the courtroom. The courtroom that's indicated is probably nominal because when you actually show up, the court could have you get sent to someplace else. And then the landlord's name and the landlord's address, and then a space for the landlord to give the reason. And you can see that it's pretty small. This is sort of the epitome of notice pleading. This is not Ianna Aquino pleading where they expect you to spell stuff out in a lot of detail. And then there's another space for the rent arrearage. And the reasons have to essentially match what's in the notice to quit. If the landlord sends a notice to quit saying you have a dog and then files a court case saying I'm evicting you for non-payment, he's got a problem, because that court case essentially is I'm evicting you because you didn't leave after I gave you notice for this reason. So the reasons have to match up. Then there are a couple fill-in lines. You'll see the name of the first justice of the court, which is already printed there. And then there's a place for the name and signature of the landlord and for the landlord's attorney if there is one. And then the right-hand column is for the alleged arrearage, as well as for contact information for the landlord or the landlord's lawyer. And then there's the box in another place giving the tenant the hearing date, and that's picked out by the landlord in advance. So the landlord has to use that summary process timeline and work his or her way back to figure out the various dates to get it done so that it all works. And there's also then a place that tells about the answer date. The answer date is also the date for discovery, and it's also the date for jury demands, although it doesn't say that on the form. Any questions about the summons and complaint or the notice to quit?
I'm sorry, what is the entry date and why is it important?
So the entry date is the date that the case has to be physically filed at the court, and the rules have a deadline, so a landlord cannot file it late, and it's tied to this overall calendar. So the entry date has to be at least a week after the tenant got, at least a week after the notice to quit has expired, and it has to be at least a week before the answer is due.
Excuse me, does the notice require the listing of every resident in the household, including minors?
It does not. It should be the tenants and only the tenants. So typically that would be the adults in the household, although the lease could define it differently. But it doesn't have to be other people who have lesser rights and are just holding under the actual tenants. So if it was me and my wife and my minor kids, my wife and I should be listed, but the kids should not be listed.
So this form here, you said it's only on file with the court?
So the return of service is only filed with the court. Normally, the tenant would not have that.
So if they tell you that they did receive service, you can go to court and confirm?
You can go to court and confirm it, or if they said they did not get, and you can go to court and see what the return of service says. Sometimes when you show it to them, they say, oh yeah, I did get that. I didn't realize that's what you were asking about. But sometimes they say, no, I never got that. The return of service shows less than usual, and then you may have a fight about whether they did get it. One more question, and then we'll move on.
Yes, what's the jurisdiction of the housing court at the courthouse? And are there tactical considerations whether you want to file somewhere else or move it to that court? Or what's the learning on where you should file or where you should seek to defend something if you're representing a tenant?
So let me answer the second part first, which is in general, we recommend if it got filed in a court, not the housing court. If it got filed in a district court or the municipal court, we recommend transferring it to the housing court, where the judges are more knowledgeable and there are more resources, including the lawyer of the day table, to help you out on it. The housing court in Boston used to be just the city of Boston, and the jurisdiction was expanded in the middle of 2017 to be sort of greater Boston heading north. The housing courts now cover the whole state, but the Eastern Housing Court in Boston is essentially the city of Boston and then the surrounding areas to the north. So we want to then move you down through the timeline. So after the tenant has been served with the summons and complaint, the tenant gets to file an answer, and we encourage you to do that. And we'll talk more about that in the next part, as well as the discovery and jury demands. For this part of summary process, everything gets measured by receipt and not by sending. So the tenant wants to do an answer, for example, the answer has to actually be received by the landlord's lawyer by the answer day. It's not like civil practice where you can just stick it into the mail. If the tenant files discovery, and serves it by the answer date. The trial date is automatically pushed back for 2 weeks. That's not to give the tenant 2 weeks, it's to give the landlord time to answer the discovery. But it's automatic and again is spelled out in the rules. Kathy?
Oh, it's a question. So if the tenant mails it in some way like certified mail or UPS, delivery confirmation, that's not good enough. It has to be actually brought to the landlord's place of business or whatever.
It's not guaranteed to be good enough. If you have sent it out, say, the Friday before, so you've given 3 days for mailing, I would be pretty confident of that in most cases. But if it, for some reason, doesn't get there, then you are likely to have a fight about what's going to happen.
What if you send it certified and they don't pick it up?
Well, it's a problem with certified mail, right? That's the downside of certified mail. So I think I would not. Typically, I would just send it by regular mail. And if you've sent it at least 3 days in advance, my experience has been generally that is going to be good enough. If you are in a position to actually get it delivered, then you can obviously have complete confidence that it's in on time.
And I think if you pay a little extra from the post office, you can get something called delivery confirmation. And so it's like you can print it off the computer that they got it.
Go ahead.
I'm sorry, you keep using a term, it's like last and usual, or?
Okay, thank you. Thank you for calling me on using legal gobbledygook. So last and usual is a term of legal gobbledygook. When you see the returns of service, that's usually what they say. And it's because the rules require service to be made in a couple ways. And one of those ways is if something is left at the place where somebody lives. That's their last and usual place of abode. And the rules say it's good enough if it was served by the right person and left there and mailed to that address as well. In summary process for the summons and complaint, service that's only last and usual isn't good enough. It either has to be in hand or last and usual plus mail. We're going to move now to the day of court. So either on the original trial day, if people didn't do discovery, or the rescheduled trial day, people show up. In the Eastern Housing Court, people have an option of going to mediation. And as you will see if you get there, the majority of people choose that. And we'll talk more about mediation in the third part of the training. And in mediation, people have an opportunity to try and settle their cases. And again, most people go to mediation and most people do in fact settle. And the settlement gets reduced to writing and becomes an order of the court. It might have terms like repayment of a rent arrearage. It might have terms like a move-out date. It might have terms like probation and then reinstatement of the tenancy. If people don't settle, they will end up in front of a judge for a bench trial, and it could be the trial that day if it doesn't get put off. So you will see people who are showing up on their original trial date and actually going to trial that day. The landlord goes first because it's the landlord's case, and then the tenant gets to present defenses and counterclaims. Typically, in the Boston Housing Court, the judge will take the matter under advisement and people will get a decision in the mail a week or two later. Let's suppose in our particular case that the landlord prevails. The landlord is able to prove the prima facie case, the elements of the case, which in a non-payment case are going to be proof of receipt of a good notice to quit for non-payment, and all of the times working correctly, and then proof of the actual non-payment. And that will make out the landlord's prima facie case. And often, in those cases, the tenant doesn't have much of a defense and the landlord does win. When I say the tenant doesn't have much of a defense, that's going to be, as you'll see in the next part, where you come in, because there may be defenses that the tenant doesn't know about. But pro se tenants may not have much to offer. So in our hypothetical example, the landlord wins and he gets possession. So he's going to get a judgment giving him possession of the property and a judgment for damages for the rent arrearage. And then those get put on the docket, and you can actually find them on, as Milton said, on mass courts, or you can call the court and find out. Go ahead.
How long do the bench trials normally last?
Question was, how long do the bench trials normally ask? And I would think 15 minutes to half an hour is probably pretty typical.
Yeah, for things like a non-payment, that's about right. If it's for other things, if it's cause, if there are a lot of witnesses, it could be longer, but they can be very, very quick.
Milton? Yep.
Okay, so after the court issues a decision, judgment, again, like Dick said, is going to enter, right? And this is what judgment looks like right here. It has the parties, right? And then it has the judge here has decided who gets possession, and if there's any money going back and forth, who gets the money and how much that is. Okay? Now, 10 days after that enters, the landlord can apply for the execution. That 10-day limit is also the timeline for an appeal for the aggrieved party, okay? So during that 10 days, if, let's say in this case, the tenant is unhappy with the decision, they can go ahead and file a notice of appeal and start the appeals process. Let's say there is no appeal. After 10 days, the landlord then applies for the execution. And this is what the execution looks like. Very similar. So the execution is the right that the landlord then has to move out a tenant or a former tenant and all their personal belongings, okay? So it looks very much like a judgment, but it's got this paragraph in here where it authorizes the sheriff to go ahead and remove a person in their property. The landlord then gives that execution to a sheriff who is now authorized to move that person out, and what the sheriff then does is they serve a notice of the levy of the execution on the former tenant. And the levy is the actual physical act of removing a person and their stuff, okay? So the sheriff has to give a minimum 48 hours notice to say, 48 hours from when you get this, I will be coming back and I'm going to move you out if you're not already gone, and we're going to move your stuff out too, if that's not gone either. So at the levy of execution, the person is actually moved if they're not gone, and the landlord is also responsible if the personal property hasn't been removed, to store that in a certified storage facility. So the landlord cannot just take a tenant's stuff and put it out on the street.
Is that the landlord's cost? Or?
It is the landlord's cost to get the sheriff, get the movers, and pay for the storage. The landlord can sue for those costs, but it's an upfront cost that the landlord has to absorb.
And all in, how much does that usually cost?
So anywhere, I think somewhere around $1,500 to $2,000. So moving someone out is an expensive proposition. When we talk about mediation later, I mean, sometimes it's a way to get maybe more favorable terms if a tenant, says like, anything that's left there can be considered abandoned property. Then the landlord doesn't have to go ahead and pay for movers, doesn't have to pay for storage. It's something you can consider. Was there another question? Yes, ma'am.
Just going back to the 10-day period to file an appeal, in your experience...
It's 10 days.
10 days.
Oh, 10 days. I thought you said 10 years. I was like, no, okay.
Did I?
No, it's 10 days. Yeah.
In your experience, what is the likelihood of success for a tenant who files a late notice? I talk to a lot of clients who...
Oh, who have missed the 10 days?
Yeah, they missed the 10 days.
So it's statutory and it can't be enlarged.
That's right.
So you can't even try. Okay.
Yes.
Is there some right created by, or is there like something like for mortgages, there's statutory redemption? Like, is there a time period where you can like pay, for example, for non-payment, what you owe, and the landlord will have to accept it? Or can the landlord just be like, didn't pay on time, time's out?
Right, so the question was, in a non-payment case, is there a right to cure? And yes, there is a right to cure. The right to cure, you can exercise it once every 12 months. And if it's a tenancy at will, which we'll talk about in a second, the cure period is 10 days after receipt of the notice. If it's a tenancy with a lease, it's all the way up to the answer date. But
And it's not limited to once a year.
oh, it's if you get a notice. If you get the notice every 12 months. Sorry about that. But if it's a tenancy with a lease, it's all the way up to the answer date. But then it's everything that the arrearage is with interest plus court costs.
Is it compounded interest? Or is there a statutory interest?
It's 12%.
Oh.
But it's not, good news is it's not compounded.
Yes, Andre?
The cure period without the lease goes to the answer date also if they don't inform you of the 10 days, I think?
That's also right. If in the notice to quit you aren't informed, so thank you. So obviously there's a lot of nuances and little rules, and we're just trying to give you, a general foundation for these things. But these are all good questions. So thanks for that. I'm not trying to keep information from you. It's just we're trying to get under a timeline. Okay, so one other thing that we want to bring up is an eviction for cause. And so we just went through, what we were calling typical eviction for a non-payment. That's the reason why the landlord brought the eviction. We also want to inform you that, a landlord can also bring an eviction for cause, which is where the landlord alleges that the tenant did something they're not supposed to or failed to do something that they are supposed to do. So typical things in a for cause eviction are violation of lease terms, destruction of property, or illegal behavior, stuff like this. And the notice to quit has to specifically state the act or omission. So, a typical for cause notice to quit might look like this, where the landlord sends the tenants a notice to quit saying you did all of these things here, right? Unauthorized people living there, renting rooms without authorization. So these might not be successful at court, but these are the reasons why they're listing in a for cause notice to quit. All the things that the landlord said the tenant did. Was there a question?
I have a quick question. Yeah. In the event, for example, we've been dealing with a situation that the person has paid rent at the beginning of the month in cash. The landlord comes in, pick up, give a receipt. Suddenly there's a situation and the landlord is sending a notice to quit, and then the guy come in, do a bank check, and we overnight at UPS, with and require a signature, The landlord wasn't at the house at the time, so they forward this package to one of these UPS pickup places.
Did this happen to you?
This
So
is happening
specific.
actually to us right now, in the
Okay.
case that we're working on. So what is, what's plan B?
So why don't we talk about that during break? The specific case. Okay, great.
Can I ask a quick question?
Yeah.
Like the previous slide that you just had out.
This guy?
Yeah, in terms of the cause for termination, do those terms need to be in the lease?
So, right, so if you have a lease, then yes.
And if they're not in there, then
Right, yeah. So, for example, we've had for cause notices to quit at the clinic when someone was being evicted for having a dog. We took a look at the lease, and there is not a no pet policy. So, there's no occupancy term that was violated. They don't get evicted. Okay, so another type of tenancy, we've been talking about a tenancy with a lease, right? Another really typical type of tenancy that we want to introduce you to is a tenancy at will. So the tenancy at will is just essentially a tenancy where there's no lease, right? It's also called a month-to-month tenancy because what happens is the tenant will pay for rent at the beginning of the month, they get to stay there for the rest of the month, and the next month they'll pay again. And this can be repeated indefinitely, right? As long as both parties agree to this, the tenant pays, landlord accepts, this type of tenancy can continue indefinitely. So the major difference, again, is there is no set date for the tenancy to end. With a lease, there is. The typical one here in Boston, right, is September 1st to August 31st. You know you have to move out then. The tenancy at will, it just goes on as long as both parties agree to it. It's also the default tenancy that exists when a lease expires and the tenant stays and the landlord's okay with it. And it's also the tenancy that exists when a landlord and a tenant want to establish a tenancy. They don't sign a lease. Tenant just wants to pay money to live there, and the landlord says that's fine. That's a tenancy at will. It's important to know that 14-day notice to quit for non-payment still applies to tenancy at will, right? So you can still be evicted for not paying, and the notice to quit that gets sent with that is still the 14-day notice. Otherwise, the notice period to terminate a tenancy at will is 30 days or a full rental period, whichever is longer. Okay? So that's important. So let's say that we're in a tenancy at will. Okay? Today is February 9th, and when we get back home, the landlord hands us a 30-day notice to quit saying the tenancy is going to end in 30 days after receipt of this or whatever. The statute says that you get a full rental period if it's longer. Again, the full rental period is, the typical one is the first of the month to the end of the month, right? So if we got that 30-day notice today, we're already partway into rental period. So our tenancy will not expire March 11th. Our tenancy will expire March 31st because the next full rental period is March 1st to March 31st. So we're going to get the benefit of that. Okay? That's also on the calendar that we showed y'all before. If it's a little bit confusing, you can take a look at that. And yes, I'm going to break out. Okay. Okay. Let's go ahead and do that. So, are there any questions right now before we go into the breakout session? Okay. So we're going to go into the breakout session. You've been distributed some materials, so you can just turn in to your group, right? And you've been given a notice to quit and a summary process summons and complaints. And you're just going to talk amongst your group for a few minutes, about 10 minutes, or 5 minutes, to figure out if there's anything wrong with the landlord's, prima facie case with just these materials, okay, with things that we just went over. So, talk amongst the people in your group, take a look at the notice to quit and summons and complaint, and we'll get back to this in 5 minutes. Okay, so I know that wasn't a lot of time, but we'd like to get on with the debrief, and so, the purpose of this was just to take a look at, what would be a typical notice to quit and summons and complaint, and see if there were any problems with the landlord's prima facie case. Y'all remember kind of what has to be shown in the landlord's prima facie case for non-payment? I'm gonna shout it out.
Actual non-payment.
Actual non-payment, yeah, that's right. That's one of the things. Sure. Another one, yeah.
Expiration of the notice to quit.
So yeah, so there are certainly notice to quit issues, right? That the tenant has to receive it, and also that the summons and complaint can't be served until the expiration of the notice to quit. That's right.
Correct notice to quit? Like
Right? Yeah, the notice to quit has to be proper on its face. Same with the summons and complaint. And again, non-payment. So those are the basic things that you have to work with what we just gave you. So, did anyone find any issues with the notice to quit and the summons and complaint? Yes.
So Lindsay Funk, who's listed on the summary process, summary complaint wasn't listed on the.
Yeah.
Lindsay Funk, who was.
Fune case, sorry, Arrested Development fans?
Okay.
There we go. So the Fune case, yes.
I've
Lindsay and
never seen
Tobias.
Arrested Development, my apologies. So
No.
Lindsay Funke was listed on the summary process, summons and complaint, but not on the notice to quit, so she hasn't actually received notice.
Yeah, very good. That's right. So the notice to quit only listed Tobias as a tenant, right? But the summons and complaint lists Lindsay and Tobias. And so it looks like the notice to quit did not list all of the tenants that were actually at the unit. So that's going to be a problem for the landlord. So that's good. Way to spot it. Yes.
Sorry, our group had a question about this.
Sure.
Like, is there an amount of time before you can no longer claim non-payment if you let someone keep living there?
That's.
Because, like, I see October 2017, they still living there on the goddamn
okay. So actually.
tent. Like, come on
Right,
now,
okay,
wait.
So, yeah, 4 months of non-payment isn't actually all that much, at least in an eviction at the housing court.
Oh.
Yeah. So I was wondering if you're thinking like 2 years or something.
Oh, no, I was thinking, like, because the first month, you don't.
So yeah,
like,
so 4 months is not unusual at all.
Oh, that's generous, I guess. Oh, okay. All right.
So the question is maybe, but that's not an issue here. Or the answer is maybe, but that's not an issue here. Yes.
Do you have to actually list out all the tenants' names, or can you say Tobias and all occupants residing there?
No, so to be a proper notice to quit and summons and complaint, all the tenants have to be named. That all is not sufficient. Or all other occupants is not sufficient. So the major issue that we wanted you to spot, yes, was that not all the tenants on the summons and complaint are on the notice to quit. That's the big one. And very much more subtle, and it would take you guys looking at the timeline and everything else, was we tried to introduce.
Well, let's see if people, now that you've told them it's a timeline issue, let's see what
All right.
people got. Oh, we got one?
So I believe the summons and complaint has to be filed after 7 days, is that right? After the expiration of the notice to quit?
So it has to be filed after the notice to quit expires. That's
Okay.
right. And so.
He got it 7 days after because. So why did you get, where did you get 7 days?
I got it from my group, this great resource here.
All right, great. Yeah, good job, group. So yeah, it looks like the summons and complaint. If you backtrack from the entry date, right, it looks like the summons and complaint which actually served early. And so.
Right, because when the summons and complaint says it was entered January 29th, so what was the last possible date for service? 22nd, right, because it
22nd,
has to be
that's right.
served 7 days before entry, and if it was served on the 22nd, how does that compare with the notice to quit? Right, because the notice to quit is dated January 10th, so if the tenant received it that day, it expired on the 24th. And the summons to complaint, if it was served on time, was served on the 22nd, which was before the notice expired. So you guys got that. Right, so you won't see the 22nd on there, but remember, the summons and complaint has to be served at least 7 days before it's entered. Right, the entry date, which you'll see on the top right of the summons and complaint, is the 29th. That means the last possible date for service was the 22nd. So if it got served on the 22nd, it got served before the notice to quit expired. And if it got served after the 22nd, it got served too late. So either way, the landlord's got a problem here.
Yes.
What happens in that instance? The landlord just goes back and starts over?
Landlord's going to have to go back and start over. If the tenant raises this, the tenant will hopefully be able to get the case dismissed because it was commenced prematurely, and then the landlord will just have to go back and do it over.
Okay, really quick, last one.
Sorry,
Yeah.
there's an empty line in the middle of the summons and complaint, and I'm wondering if it much matters. It's about where the premises are occupied.
Oh,
Does it matter because it's already, there's an address for the tenants?
I don't think so, and that was my mistake. Sorry, that wasn't something I was supposed to introduce if I missed something. Do you see that, Dave?
So the,
Oh yeah, sorry about that. I don't actually think that would be an issue. Missing that, I don't know what you think.
right. It probably would, right, because it otherwise gives it gives the tenant's address twice on the form, and so probably if the landlord left off one of those,
Okay.
the judge would say, you knew who you were and you knew where you were located.
Okay, so we're gonna have a break now. If you have any questions during the break, feel free to come up and talk to us, but go ahead, scatter. Come back in 5 minutes.